Hello everyone, welcome to Indian Judicial Service. Today we are discuss here the Indian Contract Act 1872. This video is the 8th part of top 300 MCQ of Indian Contract Act 1872. And if you are not watched the previous video, all the link of previous video is available in our description box, and those who want the PDF file of this video series, the PDF file will be available in our Telegram group, and the link of Telegram group is also available in our description box. You may join through that link. Now come to the point here. Question number 106. Under the Indian Contract Act, option A, stranger to the contract can sue. Option B, the stranger to contract cannot sue. Option C, the stranger but beneficiary under the Contract Act can sue. And option D, none of the above. So this question is directly related to the privity of contract. Privity of contract. Now we discuss here what is the privity of contract. So privity of contract means a contract cannot be enforced by a person who is not a party to the contract, even if it is a solely for his benefit. So it is clear here, a person who is not a party of the contract cannot force the contract, so cannot enforce the contract. So this is the privity of contract. Let's take example to better understanding here. So here are three persons, so this is first person, this is second person, and this is third person. It is A and he is B and another one is C. So A mortgage his property to B at rupees 10,000, and thereafter A sell same property to C at rupees 40,000. Now after C promised to B, I pay the 10,000 rupees of mortgage money of same property, and thereafter C breach such promise. C breach his promise. So in that time, B is not having a power to enforce the C to fulfill their promise due to the due to the privity of contract, because B is not a party here. So here the B is not a party in the contract. So B is not a party in the contract between A and C. Therefore the B is not having a power to enforce C to fulfill, to repay the 10,000 rupees. So this is the example of the privity of contract. Now there are some exceptions of the doctrine of privity of contract. Now we discuss these exceptions here. So exceptions to the doctrine of privity of contract. So A, in these exceptions, the A means a stranger or a person who is not a party to a contract can sue. So exception provide the power to enforce the contract here, so can sue on the contract on following cases. So which are the cases there? So we discuss there. First one is in trust. If the any person who is getting from any trust and the benefit arises, so in that time, if he is not a party of the contract, he getting any benefit, in that time he can sue. And family settlement, yes, in family settlement the third party also getting power to sue the party to the contract. And same thing is assignment of contract. And fourth one here, acknowledgement or estoppel. And now fifth here, the covenant running with land. So these are the fifth exception here. And now last exception is the contract through an agent in that time. So these are the exceptions of the privity of contract. So in now come to our question. Option A, stranger can sue. So it is wrong here. Clearly the stranger cannot sue according to the privity of contract. Option B, the stranger to the contract can sue. Yes, this is the correct option here. Stranger of the contract cannot sue here. So this thing here. And options, so it is a correct statement. Option C, the stranger but beneficiary under the contract can sue. This statement is also correct here according to the exceptions of the Contract Act. If there are any person in the related to a family matter, and the person is a beneficiary of getting an interest in the contract property, in that time if the breach of the contract, the beneficiary or third party can sue the either of the party of the contract. So option D here, none of the above. So it is clear here, both two options are there. So our answer is here option D, none of the above. Now question number 107. The contract to be a discharge. So now we discussed here contract to be discharged in the following condition. So now contract to be discharged in the mode of the discharge is discussed here. So first of all, the mode of discharge. So mode of discharge, the first mode is by agreement. So by agreement. So first mode is by agreement, and this thing is provided in section 62 to 67. And second one is there by performance. So by performance, and this thing is provided in section 37 to 67 here. And now point 3, by impossibility. So it is clear here, by impossibility, SIBILITI, impossibilities of performance. So impossibilities of performance under section 56, this is also called the forfeiture, doctrine of forfeiture here. So now option number 4 here, mode of 4. So it is by breach of contract under section 39. So these are the mode of discharge. First one is by agreement, second one is by performance of contract, third one is the impossibility of contract, and impossibility of the performance of contract, and fourth one is the breach of contract under section 39. Impossibility means doctrine of forfeiture is provided in section 56 of the contract. So it is clear here what are the mode of the discharge of the contract. Now come to our question here. The question is dealing here, the contract can be discharged. So first option, by performance of contract. Yes, this is the one of the mode of the discharge of the contract. So option B here, by frustration of contract. Yes, it is also there according to section 56, the impossibility of performance of contract. So and option C, both A and B, and option D, neither A nor B. So it is clear here, our answer is option C, both A and B. So now next question here, question number 108. 108, the novation of contract means. So novation of contract means here the option A, renewal of original contract. Option B, the substitution. This is very important. Substitution of a new contract in place of original contract. And option C, cancellation of contract. Option D, alteration of the contract. So it is clear here, novation means a substitution of new contract in place of original contract. So this thing here, and so our answer is here option B. And these provisions are related to section 62. They are dealing with the novation, recession, and these things, recession, novation, and alteration of the contract. So what are the effects of these things are mentioned in section 62 of contract. Now question number 109. The recession of contract means, so option A, the renewal of original contract. Option B, cancellation of contract. Option C, alteration of contract, and option D, substitution of new contract in place of earlier one. So it is clear here, this is the word recession here. Recession means the alteration of contract. So alteration of contract means the recession of contract. So answer is here option C. Now question number 110. A person enjoying the benefits of lawful non-gratuitous act of another. So this question is related to section 70. So section 70, this is another important word is there, gratuitous, and this question dealing with non-gratuitous. Now I separate these word, the same word here. So non-gratuitous act of another. So according to section 70, the obligation of a person enjoying the benefit of non-gratuitous act, if the same act by the person and who committing any act, who doing for the benefit of any person as a gratuitous, such person who doing such act has not power to compensate. But if he prove that he is not did same act as gratuitous, on gratuitous, in that time he have power to enforce and he have a power to get the compensation. It is clear, this thing is provided in section 70. So our question dealing with non-gratuitous. So the person enjoying the benefit of lawful non-gratuitous act of another is liable to compensate that person. Option B, is not liable to compensate that person. Option C, that another cannot claim any compensation, and option D, both B and C. So it is clear here, a person enjoying the benefit of lawful non-gratuitous act of another. So in that time another person is liable, another person having a power to enforce that person to provide him a compensation against their act. So here that person is liable to pay the compensation to another person. So our answer is here option A. Now question number 111. The claim for necessaries of life supply to minor under section 68. So section 68 dealing with the claim for necessary of life supply to minor means incapable person. So incapable persons include minor as well as unsound mind person or any other person who is incapable to maintain himself or herself. Such person is dealing in incapable person. So in that time, any person who provide the necessary of life supply, so such person has furnished such supplies is entitled to be reimbursed from the property. This is very important. From the property of such incapable person, means minor, unsound mind or any other person. So incapable person. So here the service provider or a person who furnished such supply to is entitled to reimburse from the property of such incapable person. Now option A here, the cannot be enforced at all. Option B, can be enforced against the minor personally on attaining majority. So it is clear here, the service provider is getting a compensation from the property of incapable person for their cost of the necessary supply to that person, but the incapable person is not personally liable to pay the cost of the supply of the necessary goods or services. So but the service provider is able to get the compensation from the property of the incapable person. So this option is also wrong here. Now option C here, can be enforced against the minor's property or estate. Yes, this is the appropriate option according to section 68. And option D, can be enforced against the guardian or if any or minor of minority. So it is wrong here. So answer is here option C, means the person who furnished the such supply or services can enforce against the minor's property or estate for the compensation or a reimbursement of the supply. Now question number 112. The claim for necessary of life supply to lunatic under section 68. This is the same type of question. In that question the word using minor for incapable person, and now they use the lunatic. So option A here, can be enforced against the lunatic property or estate. Option B here, can be enforced against the lunatic personally when he ceases to be a lunatic. Option C, cannot be enforced against the lunatic or his estate. And option D, can be enforced against guardian of the lunatic. So it is clear here according to the previous question, the same type of the provision here, but means a difference only the minor or lunatic, but both are treated as incapable person. So answer is here option A. The claim for necessaries of life supply to a lunatic person under section 68 can enforce against the lunatic's property or estate. So answer here option A. Now question number 113. In case of breach of contract, the compensation to be claimed under section 73. Section 73 deal with the compensation for loss or damage caused by the breach of contract. So this thing is provided in section 63 and not given by any of a remote. So this is very important number, not given. So such compensation is not given for any remote or indirect loss or damage sustained by the reason of the breach of contract. So in these conditions such compensation is not provided. Now option A, for the proximate and natural consequence of breach. Option B, for remote consequence of breach. Option C, for indirect consequence of the breach. And option D, all of the above. So it is clear here, in case of breach of contract, compensation can be claimed under section 73 for the proximate and natural consequence of the breach, not for remote consequence of the breach or indirect consequence of the breach. So it is clear here, compensation only provided in the proximate and natural consequence of the breach. So answer here option A. Now question number 114. In estimating the damage. So in estimating damage, the damage should be provided in the reasonable compensation not exceeding the amount of same. So this here same context. So option A, the mean available with the party claiming the damage to minimize the damage shall be considered. Option B, such mean shall not be considered. And option C, the party is not under any obligation to keep step within its reach or to minimize the loss. And option D, both B and C. So it is clear here, the estimate the damage, the mean available with the party claiming damage or to minimize the damage shall be considered. So answer here option A. Question number 115. A and B being traders. So here are two traders, and A and B, they are ready to involve in a contract. Enter upon a contract. So they are enter upon a contract, and A has, so this is very important, A has a private information. This is very important. A has a private information of change in price which would affect B's willingness to proceed with the contract. So let's take an example to understand this question, better understand of this question. Let's take there are A and B, and the contract between A and B on the by the A selling B the wheat at rupees 20 rupees per kg, and A get the privately information that the price of, so the price of wheat is declined to 18 rupees, but A is not liable to provide such private information to B. If B know the such information, now B reduce or reject the contract, and because of the decline the price of the goods, so or he may alter the contract. So A, in this condition, A is not liable to provide the in such information, means the price of the wheat is reduced to 18 rupees from 20. So this thing is there. So option A is bound to inform B. Option B, A is not bound to inform B. Option C, B is bound to be informed. And option D, none of the above. So it is clear here, the A is getting the private information, so A is not bound to provide this information to B, because if such information is may affect the willingness of the proceeding with the contract. So this thing here, so answer is here option B. So A is not bound to inform B. Now question number 116. Under the Indian Contract Act, consideration. So consideration is defined in section 2D of Indian Contract Act. So option A, may proceed from the promisee. Option B, may proceed from any other person. And option C, both A and B. And option D, neither A nor B. So according to the definition of consideration, when at the desire of promiser, the promisee or any other person, this is very important because these two words are relevant to our question. So when at the desire of promiser, promisee or any other person has done or abstained from doing. So here promisee or any other person. So it is clear here option C, means the under Indian Contract Act, consideration may proceed from promisee or may proceed from any other person. So both are under the definition of consideration under section 2D. So answer is here option C. Now question number 117. The Indian Contract Act, option A, third person from whom the consideration has proceeded can sue. Option B, third person cannot sue even if the consideration has proceeded from him. Option C, third person who is the beneficiary under the contract can sue. And option D, third person cannot sue at all for want of privity of contract. So it is clear here there are the exceptions of the privity of contract related to the trust or party members and the contract things. So it is clear here option C, means the third person who is the beneficiary under the contract can sue. So answer here option C. Now question number, if anybody having a doubt in this question, please post the comment in comment box, we will discuss it. Now question number 118, the executed consideration. So executed consideration means it is an act which has already been done in response to positive promise. So this is called executive consideration. Now we take the important case law related to executing consideration, which, where the judge is defined, the Supreme Court Justice Das has defined this thing. So the name of the case is the Union of India versus Chaman Lal Luna and Company. So in this case, the Justice Das decided that the definition of the executive contract, an executed consideration is an act. So executed consideration is an act for promise. So it is for promise. The act formed the consideration. So here the act formed the consideration. And another important point, no contract is formed unless the act is performed. So this thing is there. So no contract is formed unless the act is performed, and the liability outstanding on one side only, namely promisor. So here the liability is outstanding on one side only, namely promisor. Let's take an example to better understand the executed consideration. If means I, so I pay to you 1000 rupees if you find me my mobile, and you find my mobile, so your act is an executive consideration for my promise. So it is clear here, if I will pay you 1000 rupees, and if you find my watch, I promise to you, I give you offer that I will pay you 1000 rupees if you find out my mobile, and then you find my mobile, so your act is an executive consideration for my promise. So this thing is here. Now come to our question. So option A is an act or actual forbearance against a future promise. Option B, liability is, so liability is outstanding on one side only. So it is very important point here, and here important point is future promise. And option C, can be positive or negative. So it is positive and maybe negative. And option D, all of the above. So all these conditions are in executed consideration. So our answer is here option D. Now question number 119, executory consideration. In previous question we discussed executed consideration, but now this is executory consideration. So before starting this question, now we discuss these things. Executory consideration. Executory consideration means here that it is the promise for promise. So executory consideration is a promise for promise. One thing is there. Now second thing, one promise is bought to another. So one promise is bought to another. Now third is the most important thing here. The contract is concluded as soon as the promises, so the promises are exchanges. So contract is concluded as soon as the promises are exchanges. So this is called the executed contract. Let's take example to better understand this thing. So if A agree to sell, so here A agree to sell, and B, so here another person is B agree to buy. So here B is agree to buy a quantity of goods at stated price. So this is called the executory consideration. So here option means a party 1A agree to sell, and B here the party 2 agree to buy at the quantity of goods at stated price. So this transition is called executory consideration. Now, and here the both parties responsible, here both parties liable, but in executed contract the liability of outstanding on one side only, but in executory consideration the liability of outstanding on both side of party. This is the basic difference of this thing. So now option A here, consisting of promises in future. Yes, in executive consideration this is availability here, the consist of the promise in future. Option B here, liability is outstanding on both the party. In executed consideration only one side party, but here both parties is liable here. Now option C, the promise for a promise. So it is the basic statement, means first element of the executive consider, the promise for promise here. So according to it is the promise for promise. So now option D, all of them. So it is clear here all these conditions in executory consideration. So answer is here option D. Now question number 120, where a proposal and acceptance is through a letter, the contract is made. We dealt this question in previous video, and if you are not watched previous video, please watch that video and please click the like button to motivate us. Now option A, at the place where the letter of acceptance is posted, Option B, at the place where the letter where acceptance is received. Option C, at the place at which the acceptance is addressed. And option D, all of them. So it is clear here the proposal and acceptance is bought is through letter, not bought here, it's through letter. The contract is made at the place where the letter of acceptance is posted. So answer is here option A. Now finish this video. If you like this video, please click on like button. If you are not subscribed to our channel, please subscribe it and press the bell icon button which will provide you further notification of our videos. Thank you for watching Indian Judicial Service.